My name is Craig Hendry, citizen journalist reporting from the Vermilion County, Indiana jail. Today's date is November 1st, 2024, and the reason for this report is that I had court today, and it was a very eventful court hearing. I'd like to transmit some of the information that I gathered there to all of you so that you can be better informed. First off, I'm going to start out with saying that at court there was numerous deputies that were there. I don't know what the purpose of their presence was. It seemed to me an attempt to intimidate me and or anybody who would be there to support me. Tyler is the one that is, Tyler is the one that is making this phone call possible. He's on the other line. So I'm going to ask Tyler to estimate how many police officers, how many sheriff's deputies he saw inside the courthouse. Tyler, could you give the people an estimate? What's your best guess at how many police officers were there?
Yeah, so in the lobby there was probably about 4 or 5, and up at the courtroom I seen about the same amount, about 4 or 5 other officers. So there's quite a bit, about 10 or so, maybe a dozen.
Okay, so that's Tyler's estimate. I am about the same. I think that there probably was about a dozen law enforcement officers there for nothing. They know that we're peaceful. They know that we are not violent. So their presence is, in my opinion, it can only be seen as an attempt to intimidate. Now, I want to get into a few things that happened. In one of my last phone call updates, I said that the prosecution was attempting to get my criminal history put into evidence. And I posit that this is just an attempt to put me on trial for my personality and my criminal history, not for the actual events that occurred in the times in question in this case. The case is a stalking case. It has 2 misdemeanor counts of harassment along with it, and so I have to defend against these charges. But if they paint me as some sort of a criminal or as some sort of a crazy, it'll be very difficult to convince a jury that well, look, if you do all this stuff, why wouldn't he be doing all this other stuff as well? That would essentially be putting me on trial for my past and not for the events in question. So the judge asked a few questions to the prosecutor regarding entering my criminal history into evidence, and my attorney, Elizabeth Smith, who has been a real trooper throughout this whole case, argued against having my criminal history included. The prosecution made such claims as, what he wants to do is he wants to include a conviction for drug dealing, which is a conviction for marijuana dealing on my part. I have 2 marijuana convictions. It is still illegal to deal and to buy and consume marijuana in the state of Indiana. So the other conviction is a domestic violence or a domestic battery conviction that occurred at some time in the recent past, but that is an issue between me and my girlfriend. My girlfriend is still with me. We have 2 beautiful children, and we have worked out our differences despite the state trying to pry us apart at every turn. Of course, Erica didn't press the charges, the state did. So, anyways, they made a claim that, well, there's a ton of other convictions as well, Your Honor. We're just including these ones because we think that they're relevant. And of course, the relevancy of them is, it's unquestionable. It's not relevant at all. But the claim that there's that there's countless other convictions is an outright lie. Right? He has taken 3 out of my 4 convictions. I've got 4 convictions. The 3 that I've mentioned previously, and a conviction for OVWI, which is operating a vehicle while intoxicated. So those are my 4 convictions. Every other case against me has been dismissed. I mean, I've got so many dismissals, I can't even count, right? But I can count my convictions on one hand, right? There's 4 of them. So, anyways, he's just making outright lies to the court in an attempt to paint me in a bad light. But this is to be expected, right? This is to be expected from these prosecutors. They have no regard for our rights. They have no regard for the law. That would be the Constitution. They only have a regard for their own power. So, my attorney made many arguments, many sound arguments. She basically argued that, look, this is certainly a distracting piece of information to give to jurors, and that it's a subjective piece of evidence which Indiana law and Indiana trial rules prohibit the admission of it. The state refused to rebut when the judge gave them a chance. So now we're going to move on to another hearing that happened on a motion that the prosecutor made. I believe he called it a motion for direction. He was basically asking for direction from the court. He began making vague references to the phone call updates me and Tyler have been making together to bring to you. We've been working together to bring to you. It seemed as though he wanted Tyler to provide him with something, like a recording of his. My attorney pointed out correctly that any recording Tyler is in possession of, the state is also in possession of, as this facility that I'm at records all phone calls, and they are actually most likely listening right now. The prosecutor, Bruce Ackerman, continually referenced my use of the word kidnapping on these phone calls, expressing his displeasure, but conceding that I have a right to its use. Right? The judge mostly waved this off, but did say that he will most likely allow my telephone recordings to be used in evidence should the prosecutor choose to do so. We then moved on to the issue of a bond. This topic is the main topic, as I am being held in Vermilion County, Indiana, without bond. Right? So I've got written down here a few things that are absolutely necessary to understand the illegitimacy of me being held without bond. So first I'm going to read off the statute that defines bail bond. Right? So as used in this chapter, bail bond means, quote, a bond executed by a person who has been arrested for the commission of an offense for the purposes of ensuring, 1, the person's appearance at the appropriate legal proceeding, 2, another person's physical safety, or 3, the safety of the community. So there's 3 reasons that a bail bond would be instituted. There is no Indiana statute dictating when a judge must hold or release a defendant on bond. Thus, much discretion is given to judges when deciding such things. However, there are only 3 legitimate reasons, according to law, that a jurist should deny bond to a defendant in criminal proceedings. Indeed, in every case in which there exists an absence of these 3 aforementioned reasons, Indiana defendants have, quote, a constitutional right to a bail bond. Right? And that's quoted from case law. I don't have the case exactly right now, but I'll go on. The Indiana Constitution, Article 1, Section 17, reads as follows, quote, offenses other than murder or treason shall be bailable by sufficient sureties. Murder or treason shall not be bailable when the proof is evident or the presumption strong, unquote. So, in other words, offenses other than murder or treason shall be bailable. Right? This is in the Constitution. This provides a constitutional right to bail for Hoosiers. Actually it's a constitutional right that many other states don't have, and that the U.S. Constitution does not provide for. While no law explicitly exists in Indiana code, the Constitution is the law in itself. However, case law does exist that offers some guidelines to jurists with regards to bond. In Sam versus State, this is 893 Northeast 2nd District 761, this is the court citation, the Indiana Court of Appeals made clear that, quote, the object of bail is not to affect punishment in advance of conviction, as it is being used in my case. So I'm going to start over because I started as a quote. So, quote, the object of bail is not to affect punishment in advance of conviction. Rather, it is to ensure the presence of the accused when required without the hardship of incarceration before guilt has been proved and while the presumption of innocence is to be given effect, unquote. So just analyzing that quote, one can see that I've never had a failure to appear charge. I've never had a failure to appear conviction. Because anytime I failed to appear, it was because another state actor had kidnapped me in another section of the state. And I wasn't able to appear because I was in their cage. So I've never been convicted of that. I always show up dressed extremely nice, clean shaven. Tyler, will you attest to that? I mean, I always show up very nice.
Absolutely. If anything, you show up early, and you always make sure you're dressed nice. Definitely.
Absolutely. And therefore, in the case involving me, it is clear that bond should only be denied if I pose a flight risk, as there is no claim from anyone around that I am dangerous to anybody or the community. Right? And so when we look at if I'm a flight risk, I'm clearly not. So in my opinion, and in the opinion of the Indiana Court of Appeals, I would posit, me being denied bail is a punitive measure, meaning it's a measure to punish me prior to conviction. And I disagree with it wholeheartedly. I expect the trial to go on whether I'm on bond or not. And so I believe that the judge in this case, Hunter Reese, who did seem to me to be fairly neutral in such a case, but he is employed by the state. He has a history of being employed by the state. And but either way, he seemed very neutral to me, but he ignored these facts, which I assume he knows, right? Courts are presumed to know the law. So I can only presume that he knew the law and that he decided to ignore it in this case, as my attorney did not make arguments as I just presented to you. But she might yet. I mean, she didn't have this information. The Indiana bond status, the status of incarcerated Hoosiers, is that most Hoosiers are actually, they have their rights violated when they're awaiting bond, because they either can't afford the bond, it's excessive, or sometimes they have no bond at all, and there's no excuse for that. So with that being said, I think that I'm in here completely illegally, even according to their rules, and absent the bond statute, of course I'm in here illegally according to their rules. But we know for a fact that they don't follow their own rules, that they hand down decrees to us that we are expected to follow, and that we are faced with extreme punitive measures if we don't. But they themselves are only faced with a mere slap on the wrist, or not even that. But this phone call is we're getting a little bit long in it. So everybody, the trial is set for November 19th through November 21st. It could last longer, it could last shorter. I hope to see you there. I know Tyler will be there. I know a few of my other good friends will be there. And I suspect that the court will try to close the courtroom off to, not close the courtroom off, but not try to really control seating as to restrict the amount of people allowed in the courtroom. And so if you get there, make sure you get there early so that you have a seat. And if you get there and my mother or my girlfriend comes, make sure that you give your seat up for them, because those two need to be in to see their loved one's trial. So with great love and great appreciation for everybody's support, I will sign off. This is Craig Hendry, citizen journalist, signing off.